Here we are with Brian today, who is a social advocate and a human rights advocate in the past 50 years. And I just got a question for Brian on a very interesting topic. Brian, I just noticed your little ad in the Australian not too long ago, which you placed there. Why you done that? Because it's an interesting reading. Anyone can read it in 1 minute and can get the message. But why you done that? And I hope you paid for it.
Yes, I paid $5,000 plus for that little advert, and it's a little bit less than the rectangle envelope, and the print was smaller than the normal print on that paper.
So what was your ad all about?
Well, my ad was highlighting the danger of oath against oath. That is one person's word against the other, saying
In a criminal case, you have to say that.
No independent verification.
He spent 12 years in jail for a crime he didn't commit, a terrible miscarriage of justice. And when Andrew Mallard was finally released in 2006, he was ecstatic.
It's going to be the best Christmas I and my family have ever had.
In the Millard case, for example, when Millard was convicted, the family came around to me the next day. And even though I was more concerned about the DNA, but the family came with a record of interview, and I had a school teacher do a paper on it and found out it was flawed. And of course, what I really wanted to do is to go to the Shadow Attorney General at the time, which would happen to be quickly, and he's instructed his secretary he's not taken on cases. And anyway, not that I want him to take on cases, I was bringing him to the attention of cases. And what I wanted him to do is to put pressure on that they've got on public record where there's a palm print and blood. The police did the right thing, they photographed it, they filed it, but they didn't process it. And that's what I wanted to ask quickly to do, but he wouldn't listen. He wouldn't. His instructions to his secretary, I'm not interested.
Okay, why we're here now to talk about how the court system in Australia get into that stage when one say against one say is enough to convict people on serious crimes. What do you think, Brian?
Well, the fact is in Australia, people can be convicted on serious crimes on one word without independent verification, without proof, and all you've got to do is have the gift of the gab, and in most cases have Judas intentions, in other words, the 30 piece of silver, and when you put on a good show, you secure a conviction and get a payout for something that didn't happen. At the moment, people are not getting a fair trial. And unfortunately in Australia generally, and I say generally, judges, lawyers, in regard to DNA evidence, generally speaking, they have no idea. You never hear any opposition. In my younger day, I could write that advert in the form of a letter and get it published. But now the main newspapers in Australia, particularly the West, are not interested in human rights. They're just interested in people being convicted regardless of their innocence or guilt. They're not interested in the Rainey case. An interstate judge came over for the appeal, and not me saying it, but he says, the police over here just keep on lying. Now, if I said it, it means nothing, but when an interstate judge comes and says the police just keep on lying, in the Rainey case, the press didn't give them any positive or sympathy, and people can actually be convicted supposedly, or they have been convicted supposedly beyond reasonable doubt. I'm of the view that our system is dangerous, it's reckless, unjust, with the Attorney General and the Shadow Attorney General and the Leader of the Opposition and the Premier, if he wishes, and myself, to get on a panel and discuss the fairness or otherwise of our justice system.
I think that's just about time for that, Brian.
Yes.
But I don't believe they will listen to you and they will attend. Thank you, Brian. Tibor for Undercurrent.